Seminario. En este momento toca el profesor Lawrence Sager de la Universidad de Texas en Austin y va a hablar sobre Solving Religious Liberty. Larry.
I want to begin by thanking all of the folks who have been involved in this quite wonderful conference. I want to thank you for inviting me and thank all of the participants for educating me, and especially those of you who have worked hard to make the conference run smoothly and well. It's been just a delight, and thank you very much. This is a joint project. This is a joint project with Mark Greenberg. Yeah. And Mark had hoped to be here to present it with me, but personal circumstances kept him in Los Angeles. Under the circumstances, I have to take responsibility for any serious problems in the paper. We can perhaps assign minor infelicities to Mark, but the serious ones are mine. But infelicities of my expression, however, today can be attributed in part to Scott and Nikos and their preoccupation with late-night tacos and tequila. So I think that responsibility should be shared generously. Mark's in my paper is entitled Solving Religious Freedom, and it starts with that odd verb or noun, verbal noun, because we see religious freedom as deeply puzzling, as presenting an extraordinary puzzle for anyone who tries to give it shape and content. In Religion Without God, Dworkin began with this puzzle and offered his solution. As you'll see, our view is that Dworkin set the puzzle out quite well, but that his attempt to solve it does not succeed. In my remarks today, I'm going to try to solve this puzzle, but I'll begin by describing it. I'll try to show how and possibly why Dworkin goes wrong in solving it. I'll bring in Dworkin's work not just in Religion Without God, but in Hedgehogs and in Hedgehog and Life's Dominion. And in the end, I'll offer Mark's and my solution to the puzzle. I'll close with some personal remarks about Dworkin, because I feel very strongly about him. First, the puzzle. One begins with the observation that religious freedom, in some robust form, seems enormously appealing, irresistible, necessary to a well-functioning democracy. Religion, after all, has been the site of persecution, of suppression, discrimination, the provocateur of war throughout the world and over centuries. And modern human rights, civil rights treaties and charters and modern constitutions bristle with commitments to religious freedom. The United States Supreme Court and tribunals throughout the world regularly deal with cases that raise central problems in religious freedom, and indeed the highest profile case in this most recent term of the United States Supreme Court was a religious freedom-based case. However, all that said on behalf of something important in our understanding of governments and their relationship to their citizens, when you try to define and defend a view of just what religious freedom or liberty is, you immediately encounter deep difficulties, difficulties that seem to doom the project. The first of these problems, interestingly enough, is the problem of defining religion. You can encounter the problem early on by asking a very simple question, which is the question that gives rise to Ronald's title, Religion Without God. And the question is, could we possibly confine ourselves to theistic, recognizable religious faiths? in fashioning some version of religious freedom, and it is very easy to discard that possibility. Any of the reasons we have for treating religious freedom in special ways apply to sets of faiths, beliefs, and practices which do not include a traditional theistic figure. So it seems utterly arbitrary and unprincipled to stop at theistic faiths. But once we try to go a little beyond that, it turns out the problem of definition runs very deep, and there seems to be virtually no plausible stopping point, and what needs to be embraced is simply too large. One way to think about this is to think about the way people have tried to cabin religion for purposes of religious freedom, and there's essentially been two such routes. One is substantive, to try to describe what it is that unites various sets of beliefs and practices under some umbrella which we might call religion. Examples of this are religious convictions are the ones that concern what gives life meaning or value. Or religious convictions are fundamental to a person's worldview, or so on. We would look at the substance of religious beliefs. Or, and this is closely connected but different, we could define it functionally and not substantively. We could define it in terms of the role religious faith plays in a person's life, how central an organizing principle it is to their personal choices, how preoccupied they are with it, and so forth. Neither of these approaches rescue us from the problem of defining religion. One way to note the problem, and there are many different ways of seeing the problem, is understanding what either of these approaches would embrace. They would embrace, for example, deeply racist systems of belief. They would embrace systems of belief that are organized around the principle of vicious racial inequality. There'd be no way on either of these grounds to stop a group from claiming and actually believing that the most odious set of beliefs were either foundational to their belief system or fundamental to the organization of their life. So anything we did on behalf of religion would run to absolutely despicable groups and individuals. I mean, examples. We could free religion, we'll come back and talk about this, we could free religious believers from regulations that get in their way. That would threaten anti-discrimination laws in the case of a discriminatory religion. If the government can't sponsor programs that either advance or denigrate religious beliefs, then it would be impossible for the government to educate people with regard to racial equality or racism, and indeed impossible for the government to educate people in terms of great moral virtues, since many of those would center in religions. Any way we define religion, two things happen. One, it grows very capacious. It is very capacious, to the point of dooming a project utilizing the definition. But there's a second inherent problem that doesn't depend on the first, and that is any place we stop our definition of religion creates within that circle an orthodoxy and says that all the things within that circle are religious and all those things outside the circle don't qualify. That, the creation of an orthodoxy, seems antithetical to the idea that brings us to the table in the first place of religious freedom, because it puts the moral examiner or the state in the position of choosing an orthodoxy of belief. So the first of these problems concerns the capacious nature of any plausible definition of religion, the self-destructive nature of any attempt to define religion at all, and the seeming impossibility of driving religious freedom forward without some understanding of what religion is. There's a second but related problem with religious freedom. You can bring this out in various ways, but one way is to talk about a common view that people who are promoting religious freedom have about what religious freedom requires. And that common view is that what the government needs to be is, in some strong way, absolutely even-handed, but indeed hands-off with regard to religion. So the notion is that governments shouldn't benefit religion, and governments shouldn't burden religion to the greatest extent possible. This seems both even-handed and to capture some idea about religious freedom or liberty. It's captured in the United States by a metaphor that I actually deplore, but which will be recognizable to you, which is the metaphor of a wall of separation. And the idea the state is on one side of this wall, religion is on the other side of the wall. Money or support can't go from the state over to religion across that wall, and neither can the regulatory authority of the state reach over it. It's a kind of extraordinary vision, totally implausible in a modern organized state, one might note. But here is the deeper problem with it. This even-handed approach to religion just describes pockets of great partiality and unfairness. So the idea that, for example, governmental regulatory authority over religion is significantly inhibited by the demands of religious freedom means that whoever is the beneficiary of the definition of religion gets a series of benefits that everyone else is denied. Their works of art can use acrylics, and so on. I mean, just anything that motivates religious people has a presumptive right to be free from regulatory authority, and everyone else is obliged to obey the laws. And that's kind of deeply unfair structure, but so is the opposite structure that comes out of the wall of separation metaphor. And the opposite structure which comes out of the wall of separation metaphor is that if government supports various projects, social services by private groups, it can't support them if they're religiously based. So you have this odd notion that this even-handed idea of government neither benefiting nor burdening religion actually produces two misfitting and arbitrary sets of discrimination either on behalf of or against religion. So there's a kind of intrinsic and self-destructive idea to religious freedom and equality if you immediately need to undermine it with these distinct forms of partiality. All this is to say that there's nothing technical about these problems and nothing that you can simply solve quickly. These problems of defining religion and then grasping some structure of treatment of religion, assuming we can in some way wrap our hands around what it is, are intrinsically self-destructive. They fold in on themselves and create deep problems of unfairness. And those problems of unfairness, moreover, are keyed to some idea of what sort of spiritual infrastructure qualifies as religious in the first place. It seems antithetical to the general spirit in which we enter the idea of religious freedom in the first place. Yet, to go back to what I said, religious freedom seems an absolutely crucial element of a just democratic state in some way, if we could understand what it is. And it's in that set of observations that the puzzle of religious freedom arises. Now, Dworkin recognizes exactly this. And in the relevant material in Religion Without God, he sets this problem out well. He's not the only person to have observed this problem, but his case that religious liberty or freedom in this way is deeply problematic is well made. Then he sets out to solve it. And I'll spend some amount of time this morning describing his solution and its problems, and then even offering a different version of his solution that he might have drawn not from religion without God, but from justice for hedgehogs, and showing that just puts him in, that takes him out of the frying pan, but puts him in the conceptual fire. I don't think Dworkin has the resources or has presented them here to solve the problem. So my goal is to show why that is, and then to do what Ronnie did, which is to use that to motivate what I think is a solution to the problem of religious freedom. So Dworkin begins with the idea that our mistake with regard to religious freedom is assuming that religious freedom must entail a right or rights with the structure that he describes as a special right or special rights. Let me say, and if I'm pushed in conversation, I may just duck behind this, I actually think the distinction that Dworkin draws between special and general rights is somewhat conceptually problematic. But I'm going to treat it as a rough distinction, because one can get enough of a sense of it as one does from the religion without God itself. The idea of a special right is it singles out some practices or some individuals and gives them a special right or exemption from government authority, or at least a substantial restriction on authority as it reaches them. So a special right, paradigmatically, would be a right to free speech. A special right might also be a right to, well, let's just leave it at free speech as an example for the moment. I was going to talk about equal protection, but equality, but that gets, first of all, preempts myself and gets us into some difficulties. Special rights, Dworkin says, have this structure. If you're engaged in the special practice, which is privileged by this right, government can regulate you only if it is acting out of very strong governmental interests concerning the well-being of other citizens, crucial state goals, and so forth. In the United States constitutional system, that's captured by the compelling state interest test. The idea that in order for something to take place, the state, it must be necessary to the satisfaction of a compelling governmental interest. But the idea of a special right is, if you qualify for its narrowly described privileges, you get a very strong release from governmental authority or interference. That, Dworkin says, implicitly, at least in his presentation, requires you to do what it turns out you can't really do, which is define religion. Because that's what gets you into the soup of defining religion, benefiting groups that you don't want to benefit, treating other groups unfairly. It's all because we're pursuing the structure of a special right. But Dworkin says there can be a general right. And the idea of a general right is everybody qualifies for it, and essentially all behavior qualifies for it. Dworkin doesn't put it this way, but in effect, special rights limit the way government, on fairly slim grounds, can treat everybody going about their business on an everyday basis. They're really restrictions on governmental impulse, not on citizens' behavior. And so they don't require us to single out religion as a practice. They require us to focus on the purposes that government has in launching its regulation of those practices. And so they take the pressure off that I've described. Now, Dworkin's candidate for a general right of this kind is a ban on government regulation that is driven by the government's view that someone's way of life is dispreferred. This, some of you will recognize as a version of the right to ethical independence that Dworkin first flirts with in Life's Dominion, sets out at some length in Justice for Hedgehogs, and then returns to in Religion Without God, but in a much weaker form than he uses it in the other two sources. And here it is a ban on the government acting out of an impulse that someone's way of life is to be deplored. But it can act out of all kinds of impulses that are immediately adjacent to that. And let me give you some examples. Government can't ban drugs because it deems drug use shameful. And it can't ban logging just, and I'm quoting now, just because it thinks that the people who do not value great forests are despicable. So those are both banned governmental purposes. The shameful use of drugs, the despicable violation of great national treasures like forests. But the government can ban drugs to protect the community from the social costs of addiction. That's perfectly fine. And the government can ban logging, and I'm quoting now, because forests are in fact wonderful. I'm stopping now to let that sink in, because you'll understand that for every banned purpose, there immediately will be a purpose that can sincerely be restated as a social interest in avoiding the conduct, not as deploring the individual's way of life who's engaged in the conduct. So now we have a very serious problem. The first is a problem which Dworkin elsewhere, for example in Law's Empire, spends a great deal of time worrying about, which is how on earth can we parse the purpose of government as between thinking that drug use is shameful and that the costs of addiction to the community are high. And how can we distinguish between logging as a despicable carelessness of the individual or company as opposed to the importance and wonder of forests? And they're important to the climate, to history, to art, and so forth. How could we ever ferret that out, and what would it mean to ferret that out? Now, Dworkin could be talking about the actual psychological state of the legislatures that chose this. Anyone who knows the Dworkin of Law's Empire has encountered powerful conceptual and practical arguments about there even being some idea of a corporate or entity psychological state. And although Ronnie here talks in the language of psychological state, elsewhere in Religion Without God, he really indicates, he falls back on what we would expect of him, which is a constructed purpose. And a constructed purpose is immediately adjacent to or actually resident within his ideas of interpretation, as you'll remember. And it involves really trying to provide the best justification for the law in front of you. And that's its purpose, its best justification. And that's a constructed or interpretive project. Now, there's a very serious problem here, which is when you're looking at these adjacent pairs, the use of drugs is shameful, the use of drugs has high community costs. The logging of forests reflects a despicable attitude. The logging of forests really injures the society. And you try to interpret the purpose of those in the face of highly ambiguous and complex statements, indications, and histories. The thing that will best justify those laws in each case will be that which is constitutional. It will be very hard to come up with, maybe actually impossible, a view of any one of these laws which says that it is, in fact, the prohibited condemnation of lifestyle. And let me say, this isn't just a trick, hoisting Dworkin on his own interpretive petard. And it isn't just the idea that governments could easily camouflage their despising of a lifestyle as a social need. The truth is, my guess is that most often governments in these situations will be acting in whole or in part out of the perfectly legitimate impulse and not dwelling on the degree to which they deplore someone's lifestyle. So what Dworkin offers in the context of the right to ethical independence as a general right is an exceedingly slender right that, far from producing a robust version of religious liberty, will probably, in the crunch, yield virtually nothing and be extremely difficult to administer to boot. So the right to ethical independence in this form doesn't satisfy the problem of providing a robust and workable view of religious freedom. It essentially grants no territory to that right, except a kind of academic territory. Now, one thing we might do is say, well, look, Dworkin watered the right to ethical independence down for purposes of his treatment in Religion Without God. Why don't we go back to its more robust statement in Justice for Hedgehogs and see if it will do the job required of it when we put it back in its more robust form. Now, I don't know if many of you remember the right to ethical independence in Justice for Hedgehogs, but it does not make the permissibility of government action depend on the reasons for the government for acting, and it offers a much more robust protection. The canonical statement of the right to ethical independence in Justice for Hedgehog goes something like this: government may not constrain foundational independence for any reason except when this is necessary to protect the life, security, or liberties of others. And foundational independence turns out to mean those things, those actions which are motivated by fundamental impulses and fundamental judgments on the part of the actors. Now, what's interesting is, as restated in Justice for Hedgehogs, the right to ethical independence is no longer a general right. It's now a special right. It protects a limited category of behavior, that category of behavior motivated by fundamental impulses of the individuals. And while it doesn't turn on governmental motivation and offers potentially robust treatment, it simply reinstates the problems that we encountered when we were defining religion, because now we have to describe foundational independence, or what it means to act out of fundamental impulses. And everything I've said about defining religion will reassert itself. So turning to the stronger version of the right of ethical independence just puts us back in the soup of religious liberty directly. And I have no doubt that that's what pushed Dworkin to water down the right of ethical independence. But it's a little like trying to cover a big area with a small screen. When Dworkin moves from a robust right that is not dependent on elusive notions of governmental motivation to a right which doesn't demand a definitional, doesn't encounter a definitional obstacle, he doesn't produce any robust rights. If you move him back to robust, workable rights, then you're back with the definitional problem. And our commuting between these two views of the right of ethical independence indicates you can't get the virtues of both, and without both, it is not a solution to the puzzle of religious liberty. Now, in Religion Without God, Dworkin offers a kind of coda or annex to the general right of ethical independence. He brings this in under the name of equal concern. I'm going to describe what requirements he introduces in the name of equal concern. I want to say it's a little unclear how the requirements that he puts on the table really flow from equal concern, and what Dworkin has in mind in invoking equal concern and this annex or coda. I actually think that Dworkin might have in mind a deeper equality-centered approach to religious freedom, and if so, I think he was very much on the right trail. And the fact that we see this at a point, what is a kind of early point still in his working these questions out, may mean that he would have matured in his views towards what I think is the right approach, as I'll say in a minute, which is an equality-centered approach, top to bottom. Because equal concern seems kind of inexplicable in this role, and I think it's a kind of an equality-centered sensibility that is not fully realized. This is what Dworkin says in the name of equal concern. Government has to grant exemptions for activities that groups regard as sacred duties if allowing such exemptions doesn't undermine the point of the regulation that they're asking to be exempted from. So for groups that are pursuing what they perceive to be sacred duties, government has to grant exemptions if granting those exemptions would essentially cost the government nothing in terms of the purposes of the regulation. And I do mean nothing. I said substantial. It's quite ruthless in its demands. Now, this annex has two problems, which I hope by now maybe my remarks have prompted in your minds. The first is we've got sacred duty on the table now, and we have to define sacred duty. It's gotten a little more complex or interesting, but it's got all of the same problems. It seems to be a subjective, not objective, substantive view. It seems to be what the individual thinks of as sacred duty, but all the definitional problems of religion, the door is open to them once again. Moreover, what this buys for those who think they are under sacred duty is practically nothing. Dworkin's examples indicate that if there is a scintilla of governmental purpose served by denying the exemption, then this requirement of equal concern does not attach. And if there are such cases, and actually we're going to look at some real cases in a minute, or at least contrived cases. If there are cases where government has absolutely no interest in denying an exemption, they are very few and far between. And founding a theory of religious freedom on those cases would be very, very weak indeed. Moreover, in Ronald's hands here, this is keyed to sacred duty. So it seems like you have both the problems of definition and of robustness now playing at the same moment in equal concern. And curiously, no indication why this connects with equal concern. So that's really all I want to say about Dworkin and the solution to the puzzle of religion in Religion Without God. I think in important ways, frankly, he leaves us where he found us. at least if we recognize the nature of the puzzle. I don't think he offers a solution. This, in turn, motivates Mark and me to offer a solution. And in the remainder of my remarks, I'll turn to the solution that Mark and I think solves the puzzle of religious liberty. And as I've already suggested, it is equality-centered. It is driven by equality all the way down. And we think offers a way out of this. We describe this as a right to equal regard. And equal regard requires that government be equally alert and responsive to the needs of all the members of the political community. I'll say that again, and then I'll describe one of at least two entailments of that right. Equal regard requires that government be equally alert and responsive to the needs of all members of the political community. One of at least two entailments of equal regard is that all members of the political community are entitled to the treatment that a government that was fairly disposed in this way would give all its members. Now, I know that sounds frighteningly circular, but I want to say, and I'm sure that many of you would be able to express this better, that this describes a stance or a structure of thought. It's a little like, for example, Scanlon's idea of the arrangements that people could reasonably reject. Much more has to be said as to what is reasonably rejectable, but at least the question has been posed correctly. We think that equal regard is the same way, that you are entitled to the treatment that a government which was fairly disposed in the way I've described, equally alert and responsive to the needs of all its citizens would give. For purposes of how this plays out in the context of religious liberty, where government has granted or would grant an exemption from some of its rules on behalf of one group, equal regard can require that that exemption be extended to another group whose special needs for these purposes will often consist of the overlooked and undervalued needs of minority religious believers. So the way that equal regard will play out with regard to religion, it will insist that, for instance, exemptions given to one group may be required by another group. Now, all this requires more explication, and I'm going to give you three cases that illustrate the environment in which this principle could play. Let me say, these cases are not just designed as examples or as arguments on behalf of the equal regard approach. They're really designed to expose what we think is a central problem in our own view. And having exposed that, I'll try to resolve it to your satisfaction. So here are the three cases. The first case is the Saturday Sabbath observer case. And you'll recognize some of these cases as figuring in American constitutional law, but we're not interested in them from a constitutional perspective, but from a moral perspective. So in the Saturday Sabbath observer case, a state's laws are so structured as to make a Sunday Sabbath observer eligible for unemployment benefits, notwithstanding her unwillingness or inability to accept employment that requires her to work on Sunday. Okay? So in this state, Sunday Sabbath observers will never lose their unemployment benefits by virtue of being unable or unwilling to work on Sundays. The reason the question arises is that unemployment benefits, at least in the United States, say you have to be available for all feasible employment unless you have good cause not to be available. So in this state, various legal structures assure a Sunday observer that they will not lose their benefits by virtue of declining Sunday-based employment. But in this state, a Saturday Sabbath observer enjoys no such protection. And indeed, in the actual case, a Saturday Sabbath observer is found not to have good cause for declining employment that requires her to work on Saturday. So that's the Saturday Sabbath observer problem. It's the easy case among these three cases, as you'll see. Second case is the Orthodox basketball player. A high school basketball league with very strict rules about what your uniform can consist, and with strong prohibitions for any added objects not in their list. But they make an exception for eyeglasses for those whose vision is impaired without eyeglasses, assuming they are appropriately secured. However, when Orthodox Jewish basketball players wish to play with yarmulkes, bobby pinned to their hair, they deny an exemption for that. The third case is the bearded policeman case. The bearded policeman case consists of a municipal police force which requires all of its male members of its police to be clean-shaven. But it makes an exemption for individuals whose skin is extremely sensitive to shaving and makes them susceptible of a really nasty and unpleasant skin condition called folliculitis when they shave. Individuals vulnerable to folliculitis can shave, but Muslim males who understand their religion to strongly favor or indeed require that they not shave their beards are not permitted to serve on the police force unless they shave their beards. Okay, so here are three cases with, in some ways, the same structure. Sunday observers are exempted, Saturdays are not, in effect. Eyeglass wearers are exempted, yarmulke wearers are not. Folliculitis vulnerable policemen can wear beards. Muslim men cannot. So the notion is that equality, equal regard over these cases might produce rather robust entitlements. But there are problems, which I'll describe momentarily. But first, let me tell you about the case which isn't problematic. And that's the Saturday Sabbath observer case. The Sabbath case is a very straightforward case. No, it's hard to imagine that the treatment required by equal regard, the treatment that would be accorded by a government that was equally alert and responsive to the needs of all its citizens, at least without facts that are not available, could possibly justify distinguishing between Saturday observers and Sunday observers. And so that case is an easy case for the person who moves forward under the right to equal regard. But the remaining two cases are not easy. And the way in which they are not easy presents the problem that Mark and I want to identify with this view, and hopefully will resolve before I'm done today. And the problem is this. These two cases involve, in some sense, considering, in part, the differential weights of things that are either extremely difficult to weigh or indeed impossible to weigh, or certainly impossible to commensurate, incommensurate kinds of things. So they involve asking whether a government that responds to visual impairment in high school basketball players has to treat in a similar fashion the need of Orthodox Jews to wear yarmulkes. And it seems to suggest either, well, let me just, I'll come back to that in a minute. And the same thing, obviously, about folliculitis versus Muslim principles that strongly dictate that men should not shave their beards. Now, we might, if we were talking in the domain of constitutional law, about a system of constitutional rules administered by a court, we might answer this by saying, you know, there's so many reasons to fear discrimination with regard to minority religions, and such a history of discrimination against minority religions. We really ought to, in some way, presume that the weight of these religious hardships is very grave. Or we ought to presume that it's as serious as any other interest. We ought to treat it as a kind of most favored hardship, just to be safe. A set of rules that would really involve evidentiary presumptions or rules in the name of being sure that a discrimination that you fear and despise doesn't take place. But that's at the level of constitutional law. We're trying to ask the deeper question of the moral stature of these decisions by governments, and we're not going to help ourselves to presumptions or most favored hardship ideas. So we're stuck, we think, with this problem of commensurability. But I think it is in some ways solvable. And the solution requires me to speak for a moment about a distinction which I think will be familiar to many of you. And it's the distinction between treating people equally and treating people as equals. It's very possible that a conscientious decision maker allocating some important benefit or burden X as between two claimants, A and B, would allocate that benefit or burden unequally, and yet be a conscientious observer of equal regard, that someone equally alert and responsive to the needs of A and B might at times treat them differently with regard to a given X. It's a kind of commonplace. And that makes, we explain that to ourselves by saying that decision maker is treating them as equals, precisely in the sense that he or she is fully responsive to their needs and interests on an equal basis. But it just comes out differently in the two cases. So that's treatment as equals. But where there are no justifying circumstances for the different treatment of A and B with regard to X, treatment as equals requires equal treatment. In this sense, equal treatment is really derivative of the proposition in justice of treatment as equals. And equal regard, it should be pretty obvious, is for us the political morality equivalent of a government treating its citizens as equals. The difference, in order, however, to justify treating people as equals but not equally, there have to be not just morally relevant circumstances that distinguish the circumstances of A and B, but they have to be morally relevant to a degree and of a kind that actually justify the difference in treatment. there could be morally relevant differences that don't justify differences in treatment. An example we use in our paper is a sort of obvious one. A family with a fairly limited but not tiny budget has to decide, having decided to send child A to college, has to decide whether to send child B to college as well. And we imagine that in various ways, child B is less promising and deserving than was child A. But it's very possible that would be true, and yet at the end of the day, we would say a family that was equally alert and responsive to both of these two children would, on fairness grounds, owe B a college education, even though B was less entitled. It's not just a matter of morally relevant, and justifying. And it's easy to describe circumstances of unequal stature that still qualify for the demand of equal treatment. That's the sole purpose, and maybe this is all obvious, of this excursion into treatment as equal and equal treatment. Now we can say, now it's pretty obvious that the complex and elusive judgment as to whether differences in A and B justify differences in treatment with regard to X will depend on various things about X. And they are relevant to the cases that concern us here. So I want to say some things, some general things that we can say about that. One thing, we can imagine one difference among X's of the following kind. Imagine that X is located along a relatively continuous and granular scale of benefit or burden. So X is the amount of salary an employee gets, or the amount of punishment a convicted criminal suffers. And there's a wide spectrum, potentially quite gradated. In such a case, we will be more likely to find that morally relevant differences in A and B justify differences in treatment when those differences are small and granular, as opposed to binary and essentially isolated circumstances, where the question is, does a person get the job or not get the job? Does a child go to college or not go to college? Where they are essentially all or nothing cases. These will be harder cases to justify difference in treatment between A and B with regard to X. So one thing will be the granularity versus the sort of the opposite of granularity, the binary status of a benefit or burden. The second is the capacity of the decision-making entity to accommodate beneficiaries with regard to X may be quite broad or quite narrow. For example, the family's budget could be extremely tight or pretty generous. And the broader the capacity of the decision-making entity to accommodate the needs of both A and B, the less likely we will be to find that morally relevant differences between A and B are justifying of differences in treatment. All this, I think, explains why it is, and these are just examples of things we can say, all this describes why it is that when we talk about treating people, the requirement of treating people as equals, and when it produces the requirement that they be treated equally, we often say they have to be treated equally if they are, quote, similarly situated. We don't say identically situated. And similarly situated for these purposes, I hope is obvious now, is a thoroughly moralized judgment. What it means to be similarly situated in formulations like this is to have a valid claim for equal treatment, notwithstanding moral differences in your circumstances. Okay. Now, with that brief excursion, I want to go back to the two cases that I regarded as problematic. And I want to say an additional word about why they are problematic, what's worrisome about them, and then offer what I've just said by way of solution. These cases are problematic not just because the harms seem incommensurable and elusive to put on any kind of scale when we're talking about these seemingly religious harms, we're put in the worrisome position, if we adopt any of the stances I describe, of saying that if this is a religious interest, we'll treat it as a most favored hardship, or we'll give it a presumption of equality, or we treat it in any way special. We're back to religion again, because now a very particular conceptual or analytical benefit, your hardship being elevated to the maximum, will turn on whether it's a religious hardship or not. So the problem of commensurability is a very difficult one. But what we want to argue is that in cases like the two cases I've described, that are the hard cases, the basketball case and the police case, I want to argue first, these are very typical of claims on behalf of religious freedom, and that they can be resolved by equal regard without special presumptions or weight being placed on the side of religion. And the idea is this. First idea is we may not be able to say a great deal about things like the perceived requirement that Orthodox Jews wear yarmulkes or Muslim men leave their beards intact. But we have a lot of experience with them all around us. We know that people follow these practices, that they follow these practices with great persistence. They follow these practices often in circumstances where they are to their great disadvantage. We can say, for example, and this is hopelessly crude, we can say these are very important interests to these people. We can't say how important that is. We can't say whether that's larger or smaller than folliculitis or impaired vision. But we can say with some confidence that these are important interests. And having reached that view in these cases, we could make fairly strong arguments that the case for unequal treatment is inconsistent with equal regard. And that will turn not just on the nature of the interest, which may not be precisely measurable but is substantial. It will turn importantly on the governments in these cases. In these kinds of cases, and these are not, let me insist, we haven't chosen these cases to make them more attractive. They're very typical. They actually exist in the world. In these kinds of cases, government has already put in place exemptions. It's already said eyeglasses are fine. It's created an administrative structure to judge what eyeglasses are fine, when they're affixed safely, and so on. It's already said you can have bearded police officers. And there's very little claim in either of these cases that the exemptive budget is a tiny one. It's very hard to think that adding Muslim Sikhs to the Newark Police Department in addition to individuals who are vulnerable to folliculitis is going to break some exemptive bank or in some significant way be especially costly. And likewise, the addition of yarmulkes to the portfolio of those things which you can securely fix and play basketball. So the notion is these are good cases to support the view that equal regard entitles the unrequited claimants to an exemption. And our claim is that this is what is at the heart of religious freedom, a robust view of equality with regard to exemptions and certain other matters which I'll allude to just in passing. So that's the case for, or that's the solution, an equality principle centered on equal regard, the play of which is illustrated by these three cases. I said at the beginning that, how am I doing on time, by the way? Anybody? I'm fine? There's a space-time warp such that when you're on this side of a podium, everything seems lucid and clear, moving along rapidly. And on your side, it's a little different than that on all these elements. So I said at the beginning that the entitlement to the treatment that would be accorded by a government complying with the demand of equal alertness and responsiveness to the needs of its citizens was one entailment of equal regard. I'm going to offer in very brief sketch, 10-second sketch, a second entailment, which involves elaborate working out, but is significantly different. And that is equal regard on this view requires government to abstain from behavior which in sensitive contexts will have the social meaning of the denigration of groups of its citizens under circumstances where that denigration will be very costly in terms, if you will, of the equal regard that the community holds for various groups among the community. And the argument here is that in various contexts, in and around organized religious faith and activities, government partiality will carry a social meaning, a very damaging social meaning of denigration. And that in those contexts, sociological features of organized religion create very serious worries about denigrative conduct. And we could talk about those. These are actual facts on the ground now, not facts that inflect the normative environment of government behavior. They are things such as the fact that religious groups engage in very pronounced and often public symbolic behavior like prayer, that religious groups tend to be somewhat closed and clannish. You are either in them or out of them, that organized religious affiliation in at least some countries, and actually what I'm describing now may be country specific, much more specific, say, to the United States than to many European states. Religious groups tend to be, religious commitments tend to go very close to the core of identity, running in both directions, how people identify themselves and how other people in the community identify them, and a number of similar vulnerabilities to government denigration. And the idea is that a number of, and we do not explore this in the paper at any length at all at this point, that a number of limitations on government behavior that we associate with religious freedom, especially in the United States, but not exclusively, are really explicable in this second entailment of non-governmental denigration of religious groups, organized religious groups. And that includes things such as cases which prohibit the public display of religious symbols. Like in Italy, the crucifixes in schools. In the United States, tends to be things like creches in parks that raise these questions. We think school prayer, public school prayer limiting cases flow from this. We think limitations on religiously entwined curricular choices flow from this. We think a variety of limitations which in the American constitutional tradition are thought of as connected to the Establishment Clause can flow from this principle, and that it, like the treatment principle, comes out of equal regard. So that's the solution that we offer. It's equality-centered, named equal regard, and only gestured at in the paper or in my remarks. I wish I could say there's a lot of detail in the paper that will fill this in. but we hope to have more by the time we finish. And it's all I really want to say about our attempt to solve religious liberty and what we regard as Dworkin's well motivated, but in the end failed attempt to solve religious liberty. I want to close with some personal remarks about Ronald, especially since many of my remarks about his work in this area today have been critical. Dworkin's creativity and his ability to draw sharp and conceptual lines, and another quality, it was an interesting quality. In Toronto, Joseph Raz described Ronald as fearless. And I think Ronald's fearlessness combined to mean that it is impossible not to learn from Dworkin, even when one thinks that he may be wrong. In fact, maybe especially when one thinks he may be wrong. It's impossible to push off from Dworkin arguments, at least I find, without learning something significant because of his fearless and creative conceptualization and the sharp lines that he draws. And I think that's true in this area as others. I worked to hire Dworkin at NYU Law School, remarkably. Pretty noble calling from the standpoint of the law school. And I shared that faculty with him for several decades. And I developed enormous admiration for him and his work and his colloquium. And I learned an enormous amount from him. And when I learned of his mortal illness, I sent him an email that I'd like to read briefly. I'm writing to say how immensely lucky I feel to have been your student, nominally your colleague, but in my mind far more, and forever your student. Your ferocious intellect and relentless insistence on getting to the bottom things have been the stars against which I have tried to set my own reflective compass. I will always be mindful of and deeply grateful for what you have given me. I signed the email with love. I then went to get his address, which I had, and remembered that his address was R.M. Dworkin at Earthlink, to which I can only say I only wish. Thank you.
Thank you very much, Professor. Questions? I can open it up for discussion, and I can hold the cue. I have Dimitris, Nikos. Yes. Guest. Yes. Dimitris.
Right. So let me set aside for a moment the criticism that you raised against the principle of ethical independence, against the robustness of the principle of ethical independence in the version that Dworkin defends in Religion Without God. But there's one element in that principle which must be attractive and is well motivated, which is that it explains why religious practices or religious beliefs might be worth protecting. So they're worth protecting insofar as they manifest ethical independence, and that's one thing that accounts of religious freedom sometimes run into. They don't seem to show us something that makes religious practice, the practice falling under religious freedom, worth protecting. And I wonder whether your account has something equivalent or needs something equivalent. Because surely You said in response to the problem of incommensurability between health concerns of those suffering from the folliculitis and the religious concerns of Muslim men who feel that they have a religious duty to have a beard. So in response to that criticism, you said, well, it's pretty obvious that these are very important interests for them. But why are they important interests for us? The principle of ethical independence tells us that under a certain guise, they should be important for us as well. Why? Because we value ethical independence. But don't we need something similar, some similar story that would classify those religious interests as important interests worth protecting, in which case, aren't you also going to run up against the problems of defining religion very restrictively or very broadly and so forth?
It's interesting to think about whether what it is that the principle of ethical independence values. It mostly values keeping the government away from making judgments about individuals' views about what makes their life valuable. It doesn't actually say it's really important that there be such views. It really says it's important those views be unimpaired by government choices. And of course, among the views, and this is the problem, that qualify as manifestations of, quote, ethical independence are all the things people think about their lives and how to lead them, some of which are just terrible and which it's not at all clear that independent value is attached to them. But let's assume that in some sense, in order to reach the view that government can't judge people's choices, that at least the quality of choosing is something that is valued, that liberty has to flow from that. The equivalent in the context of equal regard is that what is valued and demanded is a form of equal governmental treatment of all individuals, manifest, if at all, in the broad area of across the broad fault lines of religion and non-religion, simply by a worry that that a great deal of discrimination occurs there. This is a view that doesn't privilege religion. It doesn't value religion. It protects religion, if at all, against discrimination. Now, actually, at the level of moral theory, we think that this is a principle which will have special application in the context of religion because there will often be failures of equal regard with regard to religion. But nothing at the level we've described here says that we're turning our attention to these cases because of something special about religion. In the context of constitutional doctrine that you might, or judicial doctrine that you might mount to serve the demands of equal regard, you might call forth, broadly speaking, areas where discrimination is rampant. Not saying who's a religious believer or not, but just saying those contexts where religion is called forth for benefit or special burdens or where there seems to have been neglect are areas where equal regard will attach. But that's going to be a kind of discipline of judicial attention. Here, in principle, we've offered religious cases because they're examples of how equal regard could serve the needs of a robust religious liberty, not because of something specially valuable. If anything, they're interesting instances because they are examples of rather commonplace vulnerability to discrimination. especially the first one, but all three of those. So I don't think we have to say what is especially valuable. What's valuable is the project of protecting individuals against a certain kind of discrimination.
Sure. But surely you have to, in the police force case, you have to distinguish the case of a Muslim man asking for an exemption and me asking for an exemption who's just too lazy to shave every day. And how do you do that? You do that by specifying that in the case of the Muslim man, the government has not been responsive to some really important concerns, genuinely morally important, genuinely important concerns from the point of view of political morality. Whereas in my case, it's not. When in my case I'm disciplined for failing to show up clean shaven, it's not. So in order to classify the first case as a case of unequal treatment of the pernicious sort, and distinguish it from the other case, which is not, then when we need an account of what's special, not special about religion, but what's morally important about that interest.
You're not our problem, and as a result, I think you state the problem wrong. But someone a little like you and a problem adjacent to the problem you state is one that we have to suffer. So let me explain what I mean. When I say that we can understand that these are very important concerns, that's really a subjective statement about the importance attached to wearing a beard by the individuals in question. So it is not a moral evaluation of yarmulkes and beards. It's instead a factual evaluation of the significance in the lives of these individuals that their commitments have put. That means you're no problem, because you're just lazy, as you described. On the other hand, the more interesting case for us is the case of someone who does not belong to a religious faith, doesn't necessarily describe his commitment as a religious commitment, but is in some deep way attached to his beard. That's the problematic case for us. Is there any objective way we have of excluding him from the demands of equal regard? And I think in the end the answer may be no, that he's simply eligible for equal regard. There may be all kinds of problems of proof. There may be problems of administration. They may overwhelm the situation at the level of what a constitution requires of a governmental entity. They might. But the problem is the deeply committed beard wearer, and he's a problem for us. But I think in the end, the issue will be, strictly a kind of evidentiary one. But this is a difficult issue. The other possibilities, and I'm not sure that Mark and I have resolved these. The other possibilities would be to say we're not going to demand that something be religious, but we're going to demand that the kinds of impulses that drive this commitment be sort of recognizable. That we sort of understand these as natural, ordinary commitments, even if we don't agree with them, and not just a descendant, psychological aberration. But that's very treacherous territory, even though it doesn't invite a commitment to what is religious or not religious. I mean, the kind of case that comes up in American constitutional law is the case where exemptions from military service are granted under very limited circumstances to religious objectors to all war, and along come two individuals slightly different from each other, but no one would say anything. They have to support their abhorrence of war is religious, really. But on the other hand, it's moral, and it's sort of recognizably of the same cloth as the religious. And if you posit in that case someone who had some, sort of wholly irrational set of reasons, how we would exclude them and how to think about them are really problematic. So you identify a real problem for us, but a slightly different one than you've named.
Okay, thank you very much. I have Nikos, Guest, Imer, and Skara, and I think we're going to close it there.
I have a comment about the cases and a broader comment about the approach. So in this Sabbath case, we can explain this without talking about religion at all. So as long as we allow some people not to lose the benefits on the grounds that they want a day off, then what day that is irrelevant. Okay? So we don't need to talk about religion here. I don't need to know. It is entirely, doesn't do any work in the justification of the exemption that the person who wants to not to work on the Saturday does so because of the Sabbath traditions. I don't care about that. Most of the people who take Sunday off, after all, the history of that practice is religious, but nowadays, most people just are used to the idea of taking Sunday off. And actually, we can make a case against granting an exemption there, because if we think, and we can show that this is a coordination issue, and it's better if we all take the same day off, and since, there is this history of taking Sunday off, and most of us are used to that, let's keep it like that, otherwise we have coordination problems. We don't mention religion, and we don't need to. In the case of the other two cases are harder, as you say, and in the case of the basketball, you talk about incommensurability, and I think that this is the product of conceiving of the kind of reasons that justify granting an exemption in each of these two cases, eyeglasses and yarmulke, as in terms of important needs of the individuals, in which case equal regard commits us to respecting those needs, even though there's some intuitively there's some difference between those needs. And I wonder whether, again, there is a principal distinction between the two cases in the following way. Again, we can sort of approach this matter without caring too much about religion, without talking about religion. This is relevant to my general point, which is to suggest that the kind of eliminativist view that Dworkin seems to be pushing for might have much to it. So it would be unfair for this kid to exclude him from the basketball court on the grounds that without prescription glasses, he won't be able to see where he's going. Okay? Anybody, we don't care about whether he values that. Maybe he doesn't. Maybe he hates the glasses. Maybe he wants to pretend that he's not really short-sighted. But we know that it would be unfair to him to make him to even facilitate his not wearing the glasses, let alone ban the glasses. Whereas in the case of the other kid who has the yarmulke, sure, he cares about that, but why should we, right? If there is a legitimate, an appropriate justification for the general practice of imposing a uniform appearance, a uniform, then why should we care about the fact that some kid would like also to have a yarmulke, like you said? And my worry here is that if we start saying that this is very important because it's a religious belief, then we're back in the problematic territory. There's an advantage that organized old religion has over other kind of commitments. It has all these signals and rituals and other instruments that allow people to advertise their religions and allow others to count them. It allows people, it makes people stand up and be counted, and allows others to count them. So why should we then, if we think that it's very important, the fact that it's very important in the life of that person that you work his yarmulke at all times, we're back in the familiar territory. What are you going to do with a guy who believes in Hitler was the greatest thing, and he insists on wearing Hitler was the greatest thing, and he insists on wearing an armband with a swastika at all times? Very important for him. That's all he cares about. Should we allow the swastika on the basketball court? So I think this leads me to think that maybe, I think Ronnie's approach to this is he shouldn't care so much about religion as such. There's no moral interest in it. There is more, and I think your approach, in a way, is similarly minded. We don't care about religion as such, we care about equality, equal treatment. And Dworkin thought that the genuine moral concern in the neighborhood of religious freedom was a liberty concern, moral independence. Whereas you think that the genuine moral concern in the neighborhood of religion is an egalitarian concern. But what worries me is that you seem more reluctant than Ronnie did to take this kind of skeptical, to distance yourself from the idea that religious, and indeed not the conviction part of a religion, but the public display part of a religion is very important in the lives of people. Well, again, this is a characteristic that organized all religions enjoy and possess, and I'm not persuaded that we should factor that in the calculations of what it is to regard people equally.
Thank you. These questions are important. They're not totally unfamiliar, and it's important to work them out. The connection between equal regard and religion at this point in both is very similar to ethical independence and religion in this way. We're asserting that there is a general moral value, and we're considering how that moral value plays out in the cases that happen to involve religion. We're not aiming the moral value at religion, although like Ronnie, we're in the business of solving a particular problem involving religion, namely the problem which I've described. There are many versions of rights which somewhat unproblematically help religion, by the way. For example, really robust rights of free speech give minority religious faiths an enormous amount of benefit in the United States. And they're just rights of free speech, and they're available to everyone in principle. Here, at least at the level of moral content, we want to insist that the right to the benefits of equal regard are available to everyone. And it's just that in religion, they play out in certain interesting and problematic ways. Here's how they play out. Now you say, well, why should we care? It's not just incommensurability that distinguishes the case of the yarmulke or the case of the Muslim beard from the objective case on the other side, folliculitis or glasses. Why should we care about that? And I think the reason we should care about that is these are things that matter a lot to the people who, period. They matter a lot, and they represent things that are important and can be described as hardships. It will be a hardship to shave and have a rash. Not impossible, by the way. I'm not sure just how, and in the case of New Jersey, there's no threshold that says if it was medically unbearable, it's okay, but if it's merely just really nasty, it's a condition, and you could, in principle, suffer it. You could, in principle, play basketball without a yarmulke. It's true that you probably couldn't play basketball without glasses, or at least not very well. But nevertheless, these are hardships, and they're important hardships. And we think a government that is equally alert and responsive to the needs of its citizens ought to be governed, ought to treat these cases as equal to the degree that they are similarly situated, And we make a case that the facts of cases like this, and again, I want to insist, we haven't cherry-picked these cases. These are real cases from the world of religious liberty, that cases like this don't measure up to the treatment that someone would be entitled to. It isn't in that sense at all a special privileging of religion, like free speech. In the United States, minority religious groups have been by far the greatest beneficiaries of our free speech tradition. They've also pushed that tradition along. It might be that religious groups would be special beneficiaries of equal regard. It might even be, and this would be another interesting question, that constitutional doctrine would call out discrimination in the broad domain as religion for special judicial attention and vigilance. But at the level of moral justification, it's just the fact that religious groups qualify. Now, the Nazi symbol, I think, is interesting and important, not necessarily key to our view here, but I think the answer is that a person who wears a symbol which is deeply despised, feared, constitutes in some view something approaching an assault, is not similarly situated with regard to a rule against wearing things. You can't appear naked on the court either. And if your religion requires you to play naked basketball, you're not similarly situated to the person who in every other sense is, socially acceptable, is not engaged in some, hideous speech, just happens to wear a little cap. That person, we claim, is similarly situated to the person for moral purposes who needs to wear glasses. So, and let me say, these cases will inevitably be fact-specific. It isn't possible to make broad categorical statements of moral or constitutional outcome. It will depend, for example, suppose it were the case that in Newark, a powerful part of what inspired the police department to grant folliculitis sufferers the right to wear beards was that African Americans dominated in the category of folliculitis sufferers, which may be true, by the way. And that Newark said, we did this because we have an independent and powerful commitment to racial equality. You might say, well, why don't you have it to, religious diversity or equality? But at least that would be an argument that they were not similarly situated to other would-be beard wearers. So when Mark and I have talked about this and argued about just these cases, Mark's very good at saying, well, what about this, and what about that? And the answer is, you add enough facts to the picture, you might well make out a case that justifies difference in treatment on behalf of government decision makers that are treating people as equals.
My worry was that if we look at this as a matter of needs and hardships, then the kind of cases that come into the same basket and which need to be resolved in a principled manner expands to include all sorts of organized, institutional, religious, symbols, traditions, and so on and so forth. If we look at it without paying attention, if we do not conceptualize it as a matter of hardship or need, then we might find distinctions which the hardships approach flattens. Short-sightedness and religious symbols. So sure, both are a thing on one's head, but they're very different things on one's head. They have nothing to do with a person's conception of the good life or his social allegiances and so forth.
I think the question depends on what the nature of the governmental interest on the other side is. I worry about flattening the domain of the play of equal regard. Really does not provide anything like robust protection for religious practice or irreligious practice broadly conceived. that in essence, you're quite right, Dworkin's is liberty-based, ours is equality-based. In essence, we're saying the great impulse to protect religion in world constitutions and in the United States Constitution is driven by persecution, which really is a form of inequality systematically, and that if generous equality principles are applied, we can avoid the difficulties that we started with, but have something that resembles, quotes, robust religious freedom, even though there will often be non-religious people protected against discrimination on behalf of religious people.
Just one more word. If you told me about a case that you granted an exemption or otherwise granted protection because it would be unfair not to, or because it would be an invasion of someone's liberty not to, or because it would be a kind of discrimination not to, then I'll be happy. And I wouldn't need to hear about what led you to that conclusion on the hypothesis that your moral calculations are correct. But religion would play no role in these explanations. The fact that what made this unfair was that person, by virtue of his religious commitments and allegiances, was exposed to some kind of treatment that would be unfair to allow to continue. It's neither here nor there. It could be anything.
Right. If you grant me hardship, then at the level of moral justice,
I'm not persuaded by hardship. But
that's where what you're satisfied with, and what I insist on cross is at the essentially objective facts of the subjective experience of religious believers, right, and which might apply, of course, to other people in totally different circumstances that have nothing to do with religion. I mean, a case that when I wrote about this from a constitutional standpoint, a case that my then co-author Chris Eisgruber and I talked about were these two Mrs. Campbells living across the street from each other in Richmond, Virginia. Actually, this is sort of a real case, although they weren't called Campbell. They both want to run soup kitchens. That's why. And one of them wants to run it out of religious impulses, and the other out of impulses that involve caring for her fellow people and thinking starvation is intolerable. But she would insist that religion bore on this not at all. We say, look, if government distinguishes between those two, they both, actually, soup kitchens are in various ways often barred in suburban neighborhoods. So if one of those people was granted a variance from the zoning ordinance and the other wasn't, and it connected in any way to the religiosity or non-religiosity, it didn't matter which way. It was, we think, deeply unjust.
That's right. But that's an argument for ignoring the religious character or something.
Well,
not for protecting it.
It's an interesting case. It's an interesting case because it's hard to mount a claim for hardship in either case. They've just been denied an opportunity that they valued. I think the hardship is important, and it connects in some of these cases to religiosity. And the forms of discrimination that are common may be inspired by our tradition of hostility or indifference to religious motivation, sort of a tone deafness. It's hard for many people to understand why whether a swordfish has scales or not, is really critical, right? If you're not inside the faith that makes that somehow important, it seems very strange, and you may be very quick to discount it. So, anyway.
We have to be very, very brief because we're over time.
To fill up the time.
Okay.
What I want to do was just say that Nikos said it much more eloquently than I did, and then you answered in a way that made me feel that perhaps you're not as critical of Dworkin as you make out. But I'll leave it at that, I think.
Thank you, Steve.
I'm also wondering whether Ronnie will say something like equal concern will work on its own, and you have to come with equal regard or equal respect or something like that. But that's also like something I guess we can talk a little bit more.
Let me just stop you and say there's this really odd announcement of equal concern in Religion Without God, because what follows isn't about equal concern. But I think it because as Ronald pursued this problem, I think he was really being driven or finding his way towards equality. He just didn't make it very far. But there's nothing in what he sets forth that connects directly to equality. And if it did, on my account, it wouldn't suffer the problems that his view suffers.
And still, the thing is that the similarly situated position in the Saturday and Sunday Sabbath, they are similarly situated. Whereas in the other two cases, there's different kind of reasons. And I will go for the impaired vision medical reason is clearly, and the religious reason of using the yarmulke is not that clear in that case, that it will have the same weight. And on the other case, the medical reason on the bearded policeman, the medical reason and the religious reason may be very different, but still might grant some sort of concession of the importance of, and I'm not sure if then you have to go with tolerance, religious tolerance, and even with objectors, religious objectors. Like, well, like I'm not supposed to shave, but
the reason in the paper we take a somewhat long excursion into equal treatment and treatment as equals is to insist that similarly situated is a moralized concept, and that therefore the real question is whether, in context, the distribution of this X, namely an exemption from a general regulation, leaves these two parties similarly situated. And we want to argue that there are powerful reasons for thinking that it does. But there are morally relevant differences. They just don't justify a difference in treatment.
So I find myself confused by the suggestion that this is a solution to the problem of religious freedom, or even that Ronnie had a solution, because both are attempts to treat it as a small instance of something larger. And I suppose that I heard the very beginning of your talk, and I'd read the paper, so I knew I wasn't going to get something much different, but the very beginning of your talk could have preceded a very different approach that said, look, there really is something special about religion, right? There might not have been, had there been no history of extraordinary religious persecution, of people fleeing places on account of that kind of persecution, but in light of this history, which morality certainly cares about, religion, especially identifiable religious groups that have been the subjects of persecution, really are different and really are worth marking out for a special kind of treatment, not just as a matter of constitutional law, but as a matter of morality. And then you circle back at the end and you say, out of our account on which religion isn't really special, you get this one kind of principle of anti-denigration. And I thought, no, connect that back up, connect the end of the talk to the beginning of the talk, and give yourself the ability not to be trapped to say, yeah, the person who really likes his beard, that guy is just the same kind of guy as the person who is part of a religion that is often persecuted, has been subjected to siege and war, and the refusal, right, to allow, in the condition of public employment, people to maintain the beards which are religiously required coming out of that kind of tradition, seems to me, right, when you're allowing beards for other purposes, to approach a kind of denigration, right? And so I just wonder, right? There's this, Ronnie is as much in this boat as you are, and I just don't understand why everyone wants to be in that boat of nothing special about religion. Let's talk about something else and make our special religious problems disappear.
I think that's when I treated this as a constitutional question, there were at least overtones of exactly the approach you described. One of the virtues of trying to see this at the moral level and denaturing its sum is to deal with objections that arose in that setting. And they were really very much of this incommensurability kind, and the sense that we were re-privileging a certain kind of hardship. Now, the real question is whether one can get enough from what you describe to make it work. And there are two different ways to look at this, and I think it's a very useful suggestion on your part. So one way you can look at this is the likelihood that there is discrimination in the neighborhood is much greater. And therefore, as an evidentiary matter, as a constitutional law matter, you will treat these as special cases. But really investigating the same kind of discriminatory wrong. You're suggesting that the wrong can be redescribed, and that the wrong can be redescribed as the sort of linking this to the thing which incidentally we'll write up much more fully, and I'll address more, the denigrative, the kind of material suggested by the denigration, making this look more like other forms of suspect categories in our constitutional law, for example. And we do not do this here. This is that we've sort of explicitly avoided that here. But as you say, problems like the bearded mad guy will yield to this in interesting ways, and I think it's a useful suggestion to worry about. I'm not prepared to take it on board, but I think especially when we've developed this back half, it will be interesting to see whether, as you say, it should be there at the beginning. I think, however, having said that, I don't think that I think that the case for equal regard in a straightforward way, uninflected by a special harm, I think it is a valid case, which then can be expanded on sort of evidentiary and law administering grounds. So I don't want to abandon this, and I don't think I need what you offer, but I think what you offer may be something we should think about advantaging ourselves of. Thank you.
Please join me in thanking Professor Sager for this wonderful paper. Thank you.
Thank you all very much.
Thank you, Larry. Great. So I think we should go immediately to Demetrius, or 5 minutes. 5 minutes if they need to go. Okay.